place notice for hearing in the matter of Pacific Energy and Mining Company. That's Commission docket number 18-2602-01. My name is Michael Hammer, and I am the Commission's designated presiding officer. Let's go ahead and take appearances, please.
Patricia E. Schmid with the Utah Attorney General's Office for the Division of Public Utilities.
Jeffrey Trousdale. I represent George Hoffman, the Chapter 7 trustee of the Bankruptcy Estate of Pacific Energy and Mining Company.
Are there any other parties present? Has anyone? Yes, sir. In the back.
Sorry, we filed late yesterday. Board Counsel, Assistant Attorney General for Board of Oil, Gas, and Mining.
Your name one more time, sir. Mr. Bagley, you have not been granted intervention, so I note your appearance in the room. Do you intend to move to participate in the proceeding? Because we can have you come to council's table and hear your motion to intervene, if that's your preference.
That is our preference. We'd like to be able to.
Well, why don't you go ahead and come up to council's table, and we'll hear from the other parties. I'll allow you to speak first, Mr. Bagley.
Thank you, Mr. Hammer. I know these are sensitive, so I hope I'm not shouting. Our apologies for the late filing yesterday. We filed a motion to intervene. Again, I'm representing the Board of Oil, Gas, and Mining in this dispute. Although the Division of Oil, Gas, and Mining Council is here as well, the board is the entity or agency that filed yesterday. And the reason of which was that this matter involving Wesco, which is, I believe, a gas producer around the area of this pipeline. In fact, I believe they have 18 wells that are going into a gas plant around Moab. And on December 11th, I believe, the regular scheduled board hearing, the Wesco matter was brought to the board's attention. And with respect to the issue at hand, the gas plant was, and Wesco moved for relief for the board to actually allow flaring of gas, which is statutorily defined, or at least with respect to the board's perspective, waste of a vital natural resource. And in following up after the board hearing, we've come to understand that there is quite the complexity involving the pipeline at issue. I've had at least one conference call with, forgive me, is it Tricia, trying to get the background of the dispute. And so the board wants to at least intervene for the purpose of seeing whether or not there is, or at least for the hearing officer and for the Public Service Commission to understand and appreciate the difficult situation the board is in when the pipeline may be decommissioned, or at least that's the relief I believe that's being requested, and that the board would want to be able to be on the record to be able to say a couple of different things. One is the board is not in a situation that their statutory mandate is that they cannot allow waste to occur or flaring for for very limited temporary emergency type situations. And the facts as we know them seem to indicate that either a bankruptcy proceeding or ownership issues or issues regarding the safety of the pipeline all would create a situation and a scenario where it would be untenable for the board to then allow flaring in perpetuity. And so the board would like to intervene and make sure that everybody at least understands the factual context regarding the situation, regarding the pipeline and other players and other state agencies within Utah. And that's the principal reason we're here. And also secondarily, there has been litigation involving boards being sued for flaring by various other groups. This particular gas plant is right adjacent or close in proximity to the town of Moab, and so we're also here to protect the interests of the Board of Oil and Gas and Mining to the extent there is any exposure for going forward for a decommissioned pipeline that has no clear answer in terms of when gas will be flowing again.
All right, I have some questions for you, but before we do that, I'd like to hear from the other parties just on the matter of intervention and whether there's any objection to Mr. Bagley's participation today. Ms. Schmidt?
The division has no objection to the intervention and his participation today, but requests that the division be able to make a statement concerning the points that he has raised in his statements so far this morning, at some point.
I'll allow you to do that. Let me hear from Mr. Trousdale.
No objection.
All right. Well, I suppose we'll go back to you, Ms. Schmidt, then, and go ahead and make your statement.
Thank you. The Division of Public Utilities is concerned about public safety. The Division of Public Utilities is also concerned about waste, the effect on the environment, the effect on taxes, royalties, and impacts on local communities. However, paramount in our minds is the public safety, and it is because of that that we are requesting the commission order deactivation and a penalty assessed today. Thank you.
Mr. Trousdale, do you have anything you'd like to say?
I view my role here as relatively limited, to be frank.
Understood. Well, I suppose my question for you, Mr. Bagley, then, forgive me, I'm not terribly familiar with the Board of Oil, Gas, and Mining. The company you referred to that is engaged in, is it oil drilling? Wesco, is that the name of the company?
Yes, Mr. Hammer. Wesco is the entity that is before the board in various different matters, but they're apparently the operator and or owner of the gas plant.
And the concern is that if Wesco continues to conduct its primary oil drilling operation and the pipeline is unavailable, that flaring will be necessary.
Correct. Actually, the board did on December 12th issue a 30-day order, temporary order, allowing for flaring at this time.
Does the board have authority to order Wesco to cease operations if the pipeline is unavailable?
Unfortunately, I think the testimony, particularly in this area, geologically, is that there, at least from Wesco's perspective, that the shut-in or choking back a couple of different alternatives to flaring would actually cause damage to the reservoir. And the testimony before the board is that shutting in or choking back as those alternatives are not available at the present time with respect to this. So flaring was the only alternative.
Okay, well, I suppose we'll need to develop that factual record much more elaborately than is probably appropriate at this juncture. But I think that will be the question as we weigh the competing interests of this essential public safety issue versus your obviously legitimate concerns. I'm a bit concerned that none of the pipeline parties are present today. Does anyone know why? Was anyone provided any notice of their intention not to participate?
My name is Terry Spencer. I've been counsel for PEMC. I was informed by the bankruptcy trustee that I'm not permitted to participate in this hearing.
Okay. Thank you, Mr. Spencer. What about, is Dead Horse? Is there a representative?
Christensen, I'm the operator of Dead Horse Oil LLC.
Did you have an intention to participate in the hearing, Mr. Christensen?
No.
And if I may, JMD Resources previously indicated it would participate in the hearing, but I do not see its registered agent or others associated with it in the hearing room today.
All right.
If I may as well, I just want to make sure it's clear on the record that PEMC is a debtor in a Chapter 7 bankruptcy. The trustee controls that debtor. Mr. Spencer could appear on behalf of other entities. I mean, there's no restriction for that. However, with respect to the entity that's in bankruptcy, only the trustee is authorized to take action on its behalf.
Understood, Mr. Trousdale. Let me ask, do you know, with respect to the pipeline at issue in this proceeding, who currently owns it?
We are investigating that, but we do not know. There's nothing that I've seen that conclusively establishes that PEMC owns it. I've received information to suggest that JMD Enterprises or JMD Resources, Inc. and Entrada Enterprises, LLC co-own the pipeline. I've seen information that's contrary to that, but it's all sort of up in the air. There are statutory powers available to a Chapter 7 trustee to undo certain transactions, to look back into the history of the debtor and see what's happened, and that's what we're looking at. However, there's nothing conclusive at this time.
All right. Well, of the parties who are present in this room, I believe the Division of Public Utilities is the only one that is prepared to participate and has complied with the scheduling order and actually provided a list of issues to be addressed at the hearing today. So unless there are any other preliminary matters, Ms. Schmidt, I'll allow you to call your first witness or make a statement.
Mr. Hammer, sorry to interrupt, just for the record, is the motion for the Board of Oil, Gas, and Mining granted to participate?
Yes, and I'm sorry for not stating that earlier.
Thank you.
The division would like to call Mr. Jimmy Beetham as its witness. Could he please be sworn and called to the witness stand?
Yes. Yes, Mr. Beetham, please approach. Do you swear to tell the truth, sir?
Yes.
Thank you.
Good morning.
Good morning.
I have a few preliminary questions. By whom are you employed? What is your title? And what is your business address?
I'm employed by the Division of Public Utilities, Pipeline Safety Sector. My name is Jimmy Beetham. I'm a pipeline safety engineer.
In conjunction with your employment by the division, have you participated in this docket?
Yes.
Did you prepare, or actually, if I may have a moment, I'd like to request permission to pass out some hearing exhibit books that we have prepared.
Of course. While she's doing that, I apologize to the parties. I am contending with a bout of the flu and will do my best to refrain from sniffling into the microphone or coughing, but please excuse my voice.
In conjunction with your employment, or actually, do you have a copy of the hearing book?
I'll get one. Thank you.
If you could open what's entitled the Division of Public Utilities Hearing Exhibits for hearing December 19th through 20th, 2019, to the first page, which is an index, I'll ask you some questions about some documents.
Okay.
Did you participate in providing the what is marked for identification as hearing exhibit number 1, the division's response to the commission's action request dated March 26, 2019? And in particular, did you participate in preparing what is marked as attachment 1 to that document? It's a memorandum entitled Action Request Response from the division to the commission.
Yes.
The division would like to request the admission of hearing exhibit number 1.
It's admitted.
In your conjunction with your employment at the division, could you please tell us if you are familiar with what has been marked as hearing exhibit number 3, which is the PEMC PHMSA Operator Registry Notification, OPID 39049 deactivation?
Yes.
And is it true that this document was provided by Pacific Energy and Mining Company to PHMSA and represents that PEMC will no longer be the operator of what we've been calling the Paradox Pipeline, effective 05/14/19, and that's found on the second page of that hearing exhibit.
Yes, I see that.
With that, the division would like to move for the admission of hearing exhibit number 3.
Permit me a question. Mr. Beetham, do you know how the Division of Public Utilities came to be in possession of this document?
Whenever an operator submits a change or acquisition of a pipeline, existing pipeline such as the one in Moab, our federal partners, which is PHMSA, will receive notice from the operator, and that notice would be forwarded on to state agencies such as our division.
Thank
So
you.
that's how we can get in possession of this.
It's admitted.
Mr. Beetham, if you turn to what has been marked as hearing exhibit number 6, which is entitled The Division's Status Update, dated June 12th, 2019. Are you familiar with this document in conjunction with your employment at the division?
Yes.
Do you know if this was prepared by the division and its pipeline safety section?
Yes.
And you have personal knowledge of that fact?
Yes.
With that, the division would like to move for the admission of hearing exhibit number 6.
It's admitted.
Would you like me to
Now
give
let's,
us?
now let's turn to hearing exhibit number 10. It is a division's report responding to the commission's June 14th, 2019 order. Are you familiar with this document?
Yes.
In conjunction with your employment at the division, did you participate in the preparation and filing of this document?
That's correct, yes.
With that, the division would like to move for the admission of hearing exhibit number 10.
It's admitted.
And I will note that hearing exhibit number 10 has 14 attached exhibits, and I would also like to move that those attached exhibits, which were also filed contemporaneously with the division's memorandum, be admitted as exhibits as well.
They're admitted.
Thank you. Now let's turn to hearing exhibit number 13, please. This is an OPID assignment request assigning an OPID, which is an operator identification number, to Dead Horse. Are you familiar with this document?
Yes.
Is this a document that the division would have received from PHMSA in conjunction with the division's responsibilities under its pipeline safety enforcement and inspection certificate?
Yes.
Is it true that this document represents on its face that the new operator is Dead Horse Oil Company?
Yes.
And that the date stated in this document for the OPID assignment request is August 21st of 2019?
Yes, I can confirm that.
With that, the division would like to move for the admission of hearing exhibit number 13.
It's admitted.
Let's turn now to hearing exhibit number 14, which has been marked for identification. That is the Paradox Pipeline Interim Pipeline Monitoring Program served by Terry Spencer, and the second page of the program itself is entitled Pacific Energy and Mining Company Interim Pipeline Monitoring Program. Are you familiar with this document?
Yes.
With that, I would like to move for the admission of hearing exhibit number 14, which was a document filed by PEMC, I believe, with the commission.
It's admitted.
I'd now like to move to hearing exhibit number 17, which has been marked for identification as Division's response to the Commission's August 22nd, 2019 action request. Are you familiar with this document?
Yes.
Did you participate in preparation of this document in conjunction with your employment with the division?
Yes.
With that, the division would like to move for the admission of what has been marked as hearing exhibit number 17.
It's admitted.
Mr. Beetham, do you adopt the hearing exhibits that have been admitted today as part of your testimony before this commission and hearing officer?
Yes.
With that, I'd like to move to the division's request for deactivation of what we've been calling the Paradox Pipeline. I have some questions with regard to that.
Okay.
First of all, Mr. Beetham, are you familiar with the fact that pipeline operations were suspended consistent or in response to the Commission's hazardous facility order of April 10th, 2019?
Was I familiar with it?
The fact that operations were suspended?
We just had the operator's word, but we had to verify that through a field observation.
Can you tell us the results of your field operation?
So our field operation took place in June, and we observed the pipeline's condition starting at the northwest interconnect, which is located right off the road on your way to Moab. And we started there, and we observed the conditions of their pig receiver outside of the northwest pipeline gated area. So we observed there, and we moved on to their block valve, which is near the Moab airport. And then we went to Westco, observed the condition of the pipeline at the Westco tie-in point at the Blue Hills plant, and then continued on our way down to the end of the beginning of the pipeline, which was the pig launcher and the beginning of the transmission line.
Did you review what has been marked and admitted as hearing exhibit number 17, which is the comments from the DPU regarding the interim pipeline monitoring program?
Yes, we did review that.
Could you please summarize for us why the division found the interim pipeline monitoring program insufficient and it did not bring the Paradox pipeline into compliance?
Yes, when we received their interim plan, we found it insufficient because there were some issues. Let me just turn to it to review the. There were some issues we had as far as how they were going to perform the deactivation of the pipeline, and that the type of equipment that they needed to use, the type of procedure that they were supposed to perform, and to have the documentation records involved to perform the shutdown of the pipeline.
Is it true that when the division filed documents addressing the possibility of an interim monitoring program, the division stated that, and I paraphrase, that at a minimum, there needed to be a leak survey done, including an initial leak survey, cathodic protection provided, monitored, and documented as would be done with the leak survey, and patrolling also done, monitored, and documentation provided?
Yes, so starting with the leak survey survey had to be performed along the 21 miles of the pipeline to identify any leaks. And the cathodic protection had to be performed as well to see the condition of the pipe, to see if there was still protection as far as protecting it from corroding. And then the patrolling to patrol along the pipeline to see if there's any activity, such as part of their, if anybody was doing any construction activity along the line. So a lot of the things had to be in play to provide safety for the pipeline. So a lot of it wasn't spelled out in their interim plan, so we felt that was insufficient and didn't meet those needs.
And focusing just on the leak survey, I believe that the filed interim program indicated that pressures would be taken at certain points and recorded. Is that correct, according to your recollection of what was filed for the interim monitoring program?
That is correct. However, just reading the pressure is not enough to perform a leak survey. A leak survey encompasses a lot more steps as far as just reading pressure gauges. You have to literally walk over the pipeline, use approved equipment to pick up any natural gas along the line, and be able to identify those areas that if you do come across a leak along your pipeline, that you know what you need to do in case of an emergency situation.
Did the division conduct a site visit in October of this year of the pipeline?
Yes.
I'm going to ask you a few questions about that.
Ms. Schmidt, can I ask you to put a pin in that for 1 minute? And
Of
do you mind
course.
if I ask a question to Mr. Beetham and Ms. Schmidt? This essentially is a procedural issue, so if you'd like to answer as well, that's fine. Can you all just lay some foundation as to the impetus behind the pipeline monitoring program, help us understand for the record why this was being negotiated and its purpose? And is there a reference in the CFRs or the Utah Administrative Code or statutory code that requires this or suggests that it be done?
I can address that in a limited fashion. To my knowledge, there is not a specific provision in the CFR that has monitoring prescriptive procedures that must be done. Instead, what is in the CFR is steps that must be done to comply with the pipeline regulations. Those compliance steps must be taken, and the division did not waive the necessity of complying with those when it responded to the interim monitoring plan that was filed. During this process, the division has spoken with various entities involved with the pipeline and has had settlement-type meetings with those entities. Without going too far into what could be considered settlement talks, and I believe that I am permitted to say this, the interim monitoring program filing came out as a result of some of those.
Understood. So essentially, the requirements of the monitoring program were stipulated compromises to what would be required for the Division of Public Utilities to be satisfied that the pipeline was compliant with the HFO on a going-forward basis, assuming it wasn't operating.
Perhaps stipulated is too formal of a word. It was the division's recommendations. The division, again, did note that merely having a monitoring program does not absolve a pipeline operator in a pipeline of the responsibility to comply with the pertinent regulations.
Of course, but my understanding is that the HFO ordered the pipeline to cease operations, but there were concerns about the fact that it was still packed with gas and remained unsafe. So was the intent of the monitoring program to alleviate those concerns?
As I understand it, the intent of the monitoring program was to help move the pipeline and operators into compliance. It is, although it's not mentioned in the CFR, it is an industry standard for pipeline and pipeline operators to employ an interim monitoring program when something happens. In our case, the something that happened was the imposition of the hazardous facility order and the fact that compliance had not yet been obtained by the pipeline. Often an interim monitoring program is a result of some sort of third-party damage or something. It's something that an operator undertakes as an extra and to provide a status report on an ongoing basis of what is exactly happening with the pipeline. Again, it does not supplant the other things. What the division had talked with parties about was the three specific things as a minimum, and the monitoring plan did not meet those minimum things.
I think I understand. Thank you.
Okay, thank you. And actually, let's just let's do this. Want to pass them out? No, pass this to him. I'm putting before you what let's mark as hearing exhibit number, or let's just start at
You left off at 22. 23 would be the next number.
perfect. Let's just mark it as 23. Does what I have had put before you and marked for identification as hearing exhibit number 23 represent copies of photographs that you took when you did your compliance verification site visit on October 18th, 2019?
Yes, that's correct.
Are there any points in this packet that you would like to emphasize? Or would you like the commission just to review the packet as a whole?
Let's review the packet as a whole.
Okay. With that, I'd like to move for the admission of DPU hearing exhibit number 23.
It's admitted.
And also, did the division, and you in particular, participate in a site visit of the pipeline on December 13th, 2019?
Yes.
And if I can have those distributed and marked for identification as DPU hearing exhibit number 23, we will discuss it.
Excuse me, this will be 24 that you're
24?
about to distribute.
Thank you. Okay. Well, while that is being passed out, I'm just going to ask you some questions about your observations and recollections from that site visit. Do you recall if there was a physical separation between what I'm going to call the top of the plant, or the top of the pipeline, on the end where the Dead Horse and Greentown oil and gas wells are, if there was a physical separation, such as a separation of the pipe A and B, so there was a gap in between, or temporary flanges put in place?
Are you referring to the Northwest Interconnect?
No, I'm referring to the top of the pipeline.
Top of the pipeline. So at the top of the pipeline, we did not observe any physical separation from the gathering system to the start of the transmission line.
Perfect. Was there any physical separation at the bottom of the pipeline where it would go into the Northwest pipeline facilities?
During the site visits, we did not observe any physical separation from the Northwest Interconnect, from the 2 points of pipeline.
Is it your testimony that the 11 outstanding violations that were noted in the hazardous facility order dated April 10th, 2019 are still uncured?
Yes.
Is it your testimony that as a matter of public safety, deactivation of this pipeline is required?
Required and our only option that we had.
Let's talk a little bit, and please indulge me because I'm not an engineer. I try to be one every now and then, but I'm not. Could you explain what deactivation is in layman's terms?
I'll try to be simple as possible.
Thank you.
So deactivation starts with the reduction of pressure, for one, and reduction of pressure requires that all the valves remain in a closed position, locked and secured. And once that is accomplished, then the remaining residual gas that's left within the pipeline needs to be purged completely so that there's no natural gas that's left in the pipeline, because we're concerned about that. So they had to be procedures to purge the pipeline of natural gas, to replace it with either a medium such as water or air or nitrogen. And once that's completed, then it's disconnected from the other points of entry and points of exit where you put a cap or some kind of a mechanism to separate the pipeline from any distribution of gas within the pipeline.
Once that has, are there, so there are specific steps that must be taken to do that, correct?
Yes.
Once those steps have been taken and the pipeline is deactivated, can the pipeline be restored to what I'm going to call normal operations or its regular active status?
Yes, it can be restored after doing modifications such as removing the flange that kept the pipeline from distributing gas or transporting gas.
Is it your testimony then that deactivation is required now or as soon as possible?
That is correct, because we're not confident based on, typically we would have records of the work that's being done, such as the maintenance and work that was done. Because none of those records have been provided to us, we don't have that confidence that this pipeline is operated in a safe manner.
And let's just go back for a moment. Why is having records and documentations of policies and procedures and training important?
It's important because for my line of work, we don't hold the hand of the operator, and because our resources, we do our best to arrive on site, and our duties is to look at their procedures. If they have good procedures of operating the pipeline, once we inspect that, we move forward to how well are they following those procedures through their records. And the records is a good indication that they are a prudent and a proactive operator to want to try to keep the pipeline safe. And once those records are reviewed, then we do a site visit on their facilities to determine if those records are in conjunction with what they're doing out on the field. And if the records are not provided at the time of inspection, it doesn't give us an indication or confidence again to know that they're operating this pipeline safely.
At some point, and I'm not sure of the exact date, but at some point, Dead Horse Oil Company LLC became the operator of the pipeline. Do you have confidence that this new operator is making meaningful progress towards compliance?
Well, in order for my confidence to be assured, for one, we have to have the procedures that we request from the operator, and that they would start to use those procedures as part of their documentation in maintaining the pipeline. But because we didn't receive those procedures or have any recollection of if they were going to adopt the previous operator's procedures, we just didn't know. And because we didn't know, we just don't have that assurance that the new operators of the pipeline are operating in a safe manner.
Does the fact that the new operator, Dead Horse, let me rephrase the question just a minute. Could I have just a moment, please?
Of course. Would you like a recess or just a moment?
Just a couple moments. Thank you. And I'll just continue. We talked earlier about how PHMSA provides copies of certain documents to the division as part of the division's records and its duties to do the enforcement and inspection of the interstate pipelines. Do you remember that discussion?
Yes.
Do you recall if PHMSA sent a letter to Dead Horse indicating that Dead Horse had been, and I'll use the word derelict, in not requesting of its own volition an operator ID?
I believe the discussion was that because there was a new operator, it required them to request PHMSA to have a new OPID. And because that OPID had a certain time limit after they took over the pipeline, that time limit, I believe, was 30 days. And because they didn't meet that 30 days, PHMSA came back that they were in violation of that for not reporting that they're the new operator and that new OPID had to be submitted.
Does the fact that Dead Horse did not comply with the OPID number request procedures install confidence in the division that Dead Horse will be a prudent operator?
Yes, because it's required that any
Pardon me, let me rephrase. It does or does not install confidence that Dead Horse will follow the rules and regulations?
no.
Turning now to the second part of the division's plea for relief, the division has requested that if deactivation is not achieved and proven's a very important point, by the date specified by the commission assess penalties for that failure. Do you recall that?
Yes.
Do you recall the nature or amount of penalties that the division requested be assessed?
Was that during the hazardous facility order or what we request now?
It was the request for this hearing, and if,
I believe it's the maximum penalty. And the maximum penalty, would you like me to give the amount?
no, but is it, can we turn to the commission's statutes and see that, and regulations and see that?
Yes.
Okay. If you know it offhand, that would be helpful, though.
I believe the maximum penalty would be $1 million.
Why is the commission, or sorry, why is the division convinced that deactivation is needed? Are there other methods that the division could have tried that would accomplish a safe and compliant pipeline?
I would say that we tried to explore different options, what needed to be done, but because we didn't receive procedures and records of how this pipeline was maintained, we just don't know. And because we didn't know, we erred on the side of caution and believe that this was the best option for us to request the deactivation of this pipeline. Now, the operator did provide that they shut the pipeline in. However, we still had concerns about the gas still being under the ground or within the pipeline. And because of that, we felt that that was our only option to request the deactivation of the line.
Are there particular characteristics of this pipeline, such as its location, that make deactivation the only option?
Yes, although it's in a Class 1 location, a Class 1 location means that there's not very many people who physically live around the pipeline. However, Moab is one of the heaviest outdoor recreation activity where you have Jeep safaris, you have cyclists, you have many people in outdoor activities near that pipeline. And we felt that that pipeline can be a safety concern if not being kept according to its maintenance and operation procedures, that it can be a concern to the public.
And a public safety concern, is that right?
That is correct.
Does the division recognize that having a pipeline shut in can affect reservoir pressures and production and can result in flaring or venting of gas?
Restate that question again.
Does the division recognize that if a pipeline is shut in and gas that normally flows into the pipeline can't get into the pipeline anymore, that venting or flaring of gas may be required, or that if the wells are shut in, there can be reservoir damage.
Yes.
With that, why is the division recommending that the pipeline be deactivated now?
We want to deactivate it because we want to keep the pipeline safe. Well, not the pipeline, the public safe. And although we don't want flaring because we're concerned about the environment as well, but deactivation allows us to have that confidence and assurance that this pipeline will be in a safe condition for the public safety.
Thank you. Is there a time by which the division would request the commission order deactivation?
As soon as possible.
With that, the division has no more questions for this witness at this time and makes Mr. Beetham available for cross-examination questions from the parties and from the hearing officer. Or actually, if we, and we may come back once we have, or actually, can I circulate and then move for the admission of what we would like to mark as DPU hearing exhibit number 24?
Yes, go ahead and circulate it, please.
And I apologize, these copies have not been pre-marked with the hearing exhibit number.
We will mark it Exhibit 24.
Thank you.
Mr. Beetham, earlier this morning, we talked a little bit about the division's site visit to the pipeline on December 13th, 2019. Do you recall that discussion?
Yes.
As part of that site visit, did the division take pictures and prepare of things it saw and then prepare what has been marked as DPU hearing exhibit number 24?
Yes.
If you could quickly look through what I have passed you and just make sure that I have the correct pictures. With that, the division would like to move for the admission of hearing exhibit number 24.
Yes.
It's admitted.
Thank you. With that, Mr. Beetham is available for cross-examination questions from the parties and questions from the hearing officer.
We will turn to Mr. Bagley first. Do you have any questions, sir?
Thank you, Mr. Hammer. I just have several. Forgive me, I'm kind of learning as I go, so hopefully you can help me understand this as well. So if there was a prudent operator in place, how long would it take typically to cure the 11 outstanding violations, in your opinion?
It may take some time to review the documents that they submit as far as their procedures and then the type of documentation that they're going to perform. While we do that review, we can expedite that as quickly as possible. I can't put a date on that, depending on how well we review the information that we receive from the new operator or a prudent operator of the pipeline.
Can you at least guesstimate for a range? Excuse me. Is it less than a month? More than a month?
I think it'd be quicker than that, maybe a couple days after reviewing the documents. Maybe we can speed that up as far as the review process of those documents submitted by the operator. Gives us some time to review that.
Thank you. And in terms of there was a workable or at least some sort of interim plan that was arrived at between the parties and the division. And apparently there was a breakdown with respect to that interim plan. Is that what I understand your testimony to be?
Yeah, so the interim plan that we received for the division, we reviewed that plan and found it insufficient. It was about half a page long, and typical procedures like that require several documentation as well as coordination with outside sources to ensure emergency response to the pipeline if anything were to go wrong. And so that's what we were concerned about, is that they didn't have that kind of procedure in play to do that.
And a similar question, how long would it have taken a prudent operator, if one was in place, to arrive at a workable interim plan?
If they received help from other sources like consultants, I'm pretty sure within a couple days they were able to figure that out. But because this took some substantial time in receiving this information, we just didn't have that confidence that that plan that we received was in compliance with the regulation.
Thank you. And if you know, out of curiosity's sake and for the record, if this pipeline is deactivated, how long would it then take for it to be activated?
With the removal of the flange, I think within a day, if there's just a removal of those flanges and then restoring the valves in its operational open position, and you can restore the flow of gas immediately,
And
from
just-
my experience.
Thank you. And then you testified, or at least answered some questions on other available options that you've explored with respect to this outside of decommissioning or deactivating the pipeline. Was one of those avenues that were explored was somehow appointing a temporary prudent operator in the form of a receivership for this pipeline so that safety violations, safety testing, all of that could be cured on an interim basis?
And I will object to that question to the extent that it asks for a legal conclusion concerning the authority of the division to make such a request or of the commission to grant such a request. However, I do not object if Mr. Beetham answers the question from a layman's perspective.
Yeah, overruled. If, Mr. Beetham, if you're aware of whether or not the DPU has considered that as an alternative, you're welcome to answer.
We would love the prudent operator to take over this pipeline. However, due to the circumstances that we're in, we just, I guess, could you restate that question again?
Yes, if you had it within your means, and it's a fair point with respect to the jurisdictional authority question that council has offered, but if there was a prudent operator available, would that be something that an avenue to explore, in your opinion, to get this pipeline back online and compliant with any safety issues?
I'm all in favor of an operator who's willing to do the right things and willing to take the initiative of being in compliance with the regulation and keeping their pipeline safe by doing the required recommendation of the minimum standards of our federal codes. So
Just-
yes.
Thank you. And with respect to your site visit, when you were inspecting this pipeline, tie-ins, all the infrastructure associated with that, did you also inspect any of WESCO's facilities or infrastructure that's operated by WESCO?
Our line of work only requires us to inspect the jurisdictionality of the transmission line, which is an intrastate transmission line. WESCO is an operator that is a gathering operator, so we would not inspect their facilities. However, we do inspect where they start to tie in into the transmission line at the Blue Hills plant.
Was there any issue with respect to any WESCO's infrastructure and those tie-in points?
From my observation, if you look at the pictures that I've taken, there's a physical disconnection of WESCO's pipeline into the Northwest interconnection. Or, sorry, not the Northwest, into the transmission line a physical disconnection that we observed there.
And again, for someone that represents the board and not a technical pipeline expert, what does that mean?
A physical disconnection is when they remove the flanges that connect the pipeline to the transmission pipeline and replace it with a cap on both ends to prevent any transportation of gas between the two entities, between Wesco and the transmission pipeline.
Thank you. I have no further questions.
Mr. Trousdale?
Just a couple of questions. Did you communicate with any representative of Pacific Energy and Mining Company while you were doing this inspection?
We did not communicate with the operator because this was just a site visit.
Okay.
And because this was a site visit, we did not tamper with any of the equipment. However, we just was up there to observe the condition of the valves, which we observed to be in a closed position, and that they were locked and secured, and that we also observed the pressure gauges. And that is all that we were there to do, was just to do a site visit to look at the condition of their pipeline facilities.
Okay. Have you ever had communications with a representative of Pacific Energy and Mining Company?
To my knowledge, we did not communicate that with them.
At least not you personally.
No.
Okay. Have you ever had any communications with a representative of Greentown Oil Company?
No, we did not as far as doing the site visit.
Okay. That's all.
And I just have a couple of questions, Mr. Beetham. This one may be a little redundant of some of Mr. Bagley's questions, but he asked you about how long a prudent operator, in your opinion, would require in order to remedy the 11 violations. And when I heard you answer that specific question, you answered with respect to how long it might take the Division of Public Utilities to review any documents they prepared. In your experience and in your opinion, how long would it take a prudent operator on the operator side to amend the manuals and conduct the inspections and do the other activities required to bring those 11 violations into compliance?
I didn't want to give a time frame, but because we needed to review the information that the new operator submitted to us, it just takes some time to see how well their procedure and how they're going to document is complying with the minimum standards. So that would take some time.
No, I understand that. My question is directed to the time that the operator would require in order to do the things to become compliant. I understand you're not in their position, but in your professional opinion, is that an onerous task, and would it require a lengthy amount of time?
I don't think it would take that long because those 11 violations were documentation and records issues that we did not receive from the operator at the time of inspection. So if the operator can demonstrate to us that that documentation can be taken care of or that they're going to follow that, then we wouldn't see a problem of them having, assume the acquisition of the pipeline within a short time frame.
And I believe when Mr. Bagley asked you about making the improvements or taking the actions required to comply with the interim monitoring plan, you answered that that could, in your opinion, be done possibly within days.
That's correct.
And you're welcome not to answer this question if it exceeds your area of expertise, and I recognize that it may, but if the Public Service Commission granted the division's request and the line were completely purged and shut in, what are the ramifications of purging that, all of the gas out of the line? Are there alternatives to, for example, to purging it into the atmosphere? And do you have any opinion as to the consequences of that act?
Well, we don't like to vent. However, there are ways that you could truck the gas out of the pipeline and replace it with nitrogen or with water. However, those are the options that can be considered. but we don't like to waste any natural resources such as natural gas, and venting that is a environmental issue. But if it comes down and that's our only option, then that's probably where it needs to be. But we can explore other options such as trucking the natural gas out of there and putting it in another system, or we just have to review other options. But that was our only option, either to vent out the gas or to truck it out.
Do you have a conception of the volume of gas in the pipeline and the feasibility of trucking it out?
Well, it's a 16-inch steel, it's a 16-inch diameter steel pipeline. If you calculate that and the distance of 21 miles, you can calculate the volume, how many truckloads that need to be done to remove that natural gas out of there. I can't calculate that. I don't have that calculation now, but doing some sound engineering calculation, you can come up with a determination how long that would take.
Do you have a preliminary opinion as to whether that would be prohibitively expensive?
There is a cost associated to that, but I can't determine that right now without doing some calculations.
Understood. I have no other questions. Ms. Schmidt, do you have any redirect?
Very limited, thank you. Mr. Beetham, Mr. Trousdale asked you some questions about communications with PEMC. Do you recall that conversation?
Yes,
Is it true that the division, at least since 2016, and even has had communications with PEMC about the 11 outstanding violations?
we did have communications with that, yes.
And is it true that if you know, if the division has continued to copy PEMC on filings it has made with the commission even after PEMC resigned as operator?
Yes,
And is it your experience that at least up until today, PEMC participated in this proceeding? In this docket, sorry.
yes.
We talked a little bit about, you were asked by the hearing officer about the nature of the violations. And is it true that although they are records and documentation violations, having those records and following those procedures is essential to protect the public?
Yes.
And so it's more than just paperwork, is that correct?
It is more than paperwork. Actually, there's the work that needs to go into on the operator side to perform that work according to their procedures.
And you were asked some questions about a hypothetical new operator. Do you recall that discussion?
Yes,
We talked, and you indicated that it is possible that a dedicated, committed new operator could relatively quickly cure the violations and bring the pipeline back into regular active status. Is that a fair laywoman's characterization of your testimony?
if they had the right resources, and yes,
We don't have a new we don't, let me strike that. Does the division still stand by its recommendation that the pipeline be deactivated now in order to protect the public safety?
yes.
Thank you. Those are all my redirect questions.
Thank you. Mr. Beetham, you're excused. Mr. Bagley, you do not intend to call a witness, is that right?
No, Mr. Hammer, but we do have counsel for the division that has a more accurate understanding of the chronology in front of the Board of Oil and Gas and Mining with respect to this issue and the flaring, if the hearing examiner would like to hear from him at all.
we'll come back to that. Mr. Trousdale, you don't expect to call a witness, correct?
No.
Thank you. We'll move on. Then I suppose my question, Mr. Bagley, is has the board contemplated a process that it would like to see happen for the PSC to incorporate its concerns into this proceeding, given that the board only moved for intervention yesterday? Obviously, in the division's view, the public safety circumstances are rather exigent. Do you have a proposed process?
Mr. Hammer, the board would want to make sure and clarify that that the board completely understands the division's need to end and mandate itself to make sure that the public health and safety is assured. That relief and remedy is certainly within the division's purview, and the board has no objection to that type of relief. My marching orders, if you will, came as a result of the Wesco proceeding and the concern over flaring and continuation of that flaring issue involving an innocent third party, which is Wesco in this dispute, a deactivation of a pipeline that could be in perpetuity because we do not know how long this would take, and that the board made at least an effort to say, well, we want to do a resolution to see if whether or not the Public Service Commission understands and appreciates the bind the board is in when there's a general disdain for wasting natural resources first, concern over the environment second, and third, getting in the middle of some sort of dispute involving multiple parties. The testimony before the board was that it's not only a situation with respect to waste being a concern, but it's elevated to the fact that Wesco, before the board, actually has to pay royalties to gas that is going to be flaring. So it's a compounded issue, compounded problem, and that the board's real concern is that there is not it's an open-ended deactivation period, and that the flaring goes well beyond. Right now, we only have a 30-day flaring order that's allowing, I believe, 400 MCF allowances for the next board hearing, which will be the end of January. And so, again, I think the public service, the division's in a bind, the board's in a bind, the division's in a bind, and we just want to at least see if there's clarification that the record is completely clear that there is a situation here and the board is involved in it, and that whether or not, to the extent they can add to the factual record or understanding of the scenario and help to arrive at a solution, that would be wonderful too.
Ms. Schmidt, do you have anything to say on that matter?
Just that it is the position of the division that public safety and safety of the public is paramount. Thank you.
Mr. Hammer, if I may, you asked, and I don't believe I effectively addressed your question, is whether or not there's some sort of plan. I apologize for that. The only plan that is basically from council for the division and board wondering whether or not there could be, and we do not know this, the appointment of some sort of temporary receiver type scenario where a prudent operator is appointed to cure all the safety violations, and that because the prudent operator is in place, whether or not that could then resolve and cure all the outstanding safety violations in somewhat expedited manner, and also allow then, so that would satisfy the division's concerns for any safety violations, and then someone could get back up to speed so the gas could be allowed to flow and the flaring could be alleviated.
Understood. Well, of course, you are all welcome to have those discussions at length outside of this official proceeding. I encourage you to do so. If there's nothing else, we'll adjourn. Thank you, everyone.